still got about 5 minutes, folks. I mean, mindful of some of the media might be running a little behind. Give them an opportunity to get it. 5 minutes. Start at 7 o'clock.
Just gonna delay it a little bit.
Oh, I'm sorry.
You'll have time to run with it when I'm here. His phone is on.
You got something in your phone that you don't know.
Oh, channel, the Herald was going to make it. They said, can somebody please take a picture? Vanessa Dan Young said he couldn't make it, but he'll, we can get it to him in time, and he'll get it on in the newspaper. I don't see the Inquirer.
I got them covered.
Inquire. They close your brain.
19 here.
I'm sorry, I thought they were 19. I said 19 counties, the Inquirer, they work together.
So that were them. When do you want it?
Now.
What do you want?
Justice.
Justice!
When do we want it?
Now!
What do we want?
Justice!
When do we want it?
Now!
What do we want?
Justice!
When do we want it?
Now!
What do we want?
Justice!
When do we want it? Exonerate! 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 Judge Hunter now!
All right, we're going to get started.
It's over.
As you can see, the energy is still alive and well regarding what has happened to Judge Hunter since 2010 all the way up until now, and the fight still goes on. And there was some discussion with Joe Dieters at one of our last events where Mr. Dieters said he was not even aware, and I understand he wasn't aware of the court fees that were levied against the judge. So we're calling this press conference to bring awareness to what is going on and bring the media up to speed as to where we are. There were some motions filed regarding the court fees, as well as a motion to vacate the sentence. The motion to vacate the sentence was filed back in July. I believe it was July the 27th. Our judge, Dinkelacke, has chose not to rule on that to this point. It's been well past 6 months. And from what I can gather, a judge has 120 days to rule on issues that is before him under the procedures of the Supreme Court. Now, the other motion was the motion regarding the court costs. As you all are aware, she was found guilty of the one charge. Now, I'm speaking from a police officer's standpoint. Let me speak on that for a minute. Oftentimes, police officers, and you all have heard of the term, throw the book at you. And oftentimes that will occur. They throw the book at you and, in essence, hoping that they get one of the charges to stick. Well, I akin that to what occurred with Judge Hunter. They threw the book at her. The prosecutors came up with over 9 charges against her. And with the intent of, as always, if you throw enough charges at her, maybe one will stick. So, obviously, they got what they wanted. They got the one charge to stick. But that was not the end of it. They then said, well, we're going to retry her on the other charges because it was a hung jury. So, in doing so, they then began the process of getting transcripts printed up, sending out all kinds of subpoenas, just running up the cost, and all of these things. Now, mind you, the conviction was October the 14th on that one charge, which was count 6, I believe it was. At that point, they went, as I said, they moved forward to gather information more, to prepare for the next trial. The attorneys just did all kinds, just ran the dollars up. So as a result, the date that they were prepared to move forward with the next trial, they decided, well, Your Honor, we got a conviction on the one charge. We're going to voluntarily dismiss the other counts. And in doing so, that was their prerogative. They had the right to do that. Well, Ohio law is clear in that you only can be charged on for the amount of, for the charges that you're convicted on. And in this case, the charges were voluntarily dismissed by the prosecutor. So it makes no sense. It defies logic for a prosecutor to decide, well, I'm going to retry you since I couldn't get a conviction the first time. I'm going to retry you, and I'm going to run all these fees up to the tune of $34,559.66. And then I'm going to drop the charges voluntarily, but I'm going to charge you for all the work that I did to try to decide whether I was going to retry you. So it defies logic to say that the charges that were, it wasn't charges that were, the jury couldn't reach a verdict or anything or whatever. These charges were dismissed voluntarily by the prosecutor. So it stands to reason that she should not be charged all of those fees. So the motion was filed, and the motion clearly spelled out exactly what should have occurred in that situation. And my understanding, there were 8 or 9 charges, please don't hold me to that, but whatever the number of charges were. And the conviction on the one, when you look at that conviction, that has nothing to do with anything going forward. And a whole lot of the expense was having transcripts printed up to prepare to go to trial a second time. So why should she pay for all of those transcripts that the prosecution realized that she was not going to shy away from fighting this case a second time? And the day of the hearing, in the courtroom, they decided we're going to drop the charges or dismiss those charges. So this is why we're here. Now, Judge Dinkelak, he just hasn't ruled on it at all. That was July the 27th. He hadn't ruled. The second motion, the prosecution didn't even file a response, basically saying, we don't object, Your Honor, to these charges being properly serviced and properly applied. And as we and the community's behind it, trying to help out. But again, we're not going to stand by and let the judge be railroaded into paying fees that she had no control whatsoever over. And so when you think of all of this in the context, what's in that motion by Jennifer Branch is basically what she should be.
Actually, I should not be held accountable for any of the charges because even on count 6, 3 jurors all came forward and said the guilty was not their verdict. Secondly, most importantly, on the day that the prosecutors dismissed all of the charges, they dismissed those charges immediately following the discovery by myself and my attorneys after looking at all of the computers at juvenile court that the prosecutors and or the juvenile court tampered with the computers, destroyed the hard drives, and then got rid of the computers. I never had access to the computers during those 2 years of trial. In fact, I did not know until the second trial was scheduled to proceed that the computers had been tampered with and also the hard drive sold. That was admitted by the lawyers and the prosecutors. And so I'm continuing today to maintain my innocence. I shouldn't be held accountable for the charges on count 6, nor definitely the 9 charges that were additionally dismissed after it was discovered that they tampered with the computers.
So with that being said as well, what really stood out that caused us to really say something wrong with this entire picture? First of all, never in the history of the county has there ever been this amount charged to anyone. We checked with the clerk, we did research, we could not find anywhere where $34,000 in fees were levied against anyone. Second of all, we couldn't find anywhere where someone had to pay for the media to be a part of the hearing process. I just got one, there were several requests by the media. This particular one was with WKRC. So in other words, and I think you all were not aware that when you all applied to be in the courtroom, they charge, and then they charge that to the losing party in the courtroom. These things makes no sense. So what we're saying to Judge Dinkelak, do the right thing and rule in Judge Hunter's favor. And if you choose not to do the right thing and you're going to rule another way, at least make a ruling so that the 2 motions can move forward throughout the system. But to hold those motions in abeyance and to allow Judge Hunter to have to continue to endure all of this this stress, it makes no sense. It's over with that. So that's why we are having this press conference. That's what I'm saying. So that's why we're having this press conference. We're here. We want those cases to move forward because we firmly believe that Judge Hunter, number one, never should have been charged with anything. Never.
Never should have been.
And Lord knows that when Judge DeWine did his thing and asked Joe Dieters to hire his son, that was clear violation of the ethics laws. That's why they have the ethics laws. And so when he hired him and gave him a paid position, the laws are clear. But they have ignored that. So this is why we're here today. And I'm glad to entertain any questions. The packet speaks for itself. The motions, and you all have easily get a copy of them. David Singleton's motion, I gave you the cover page where you can download the motion, and I think they both speak for themselves. But we can't go do anything at this point until Judge Nicolak can make a decision. And the courts are very clear. 120 days is as best we can find in terms of research, and it's been over 6 months on the one charge, and we're going into, I believe, the third month on the other charge. I think it was Jennifer filed in November. So. In jail and all these other things, but she's still here and the community's still behind her.
Unconstitutional. Lawyer and judge, that's the best that I can call it. I mean, it's unjust, but from a legal perspective, it's unconstitutional. It's a violation of the 8th Amendment.
Yeah, the way we see, I've been tied to the criminal justice system since 1970. And if it's something that may be a lot more than they can handle, then their credit's ruined through this process. They can't do anything until those fines are paid. And putting $34,000 on the judge, basically that's saying, until you pay that fine, you're not going to be able to do anything in this county. And that's the message that they've sent, knowing that they've taken her law license away, knowing that she did not have an income of any significance. This is why the community got behind her.
Now they got behind me because what happened is wrong.
Okay. I'm talking about going forward. We've been behind you. We've been behind us since the beginning. So we're not going to let them take actions against her while he decides to hold those motions in abeyance. And we just going to be prepared to take some action if necessary. If we choose not to.
To the best of your knowledge, if that time expires and the judge has done nothing, what happens then, or what are you prepared to do after that, or
Well,
can you do?
I think the first step would be to compel him to rule through the Supreme Court. Yeah, you have to compel him to rule. He can't just sit on those indefinitely. You know, the law was clear based on the research we've done that he does have 120 days to rule. You know, he may say, well, no, that's not true.
Well, actually, in normal cases, is you can say it's 120 days, but when there's a case, when there's a reason to rule more expedient than that, then the judge has a responsibility to do that. I heard emergency motions all the time, and the fact that the probation has been directed directly tied to these court costs. And my life is being held in abeyance while the court costs are pending. That is all of the more reason for a judge to rule more expedient and not to wait 120 days. This motion was filed as a motion that time is of the essence, and that's how the legal system is typically required to respond to those type of motions.
And when she tried to, when the attorneys attempted to pay the first amount, the system was not even set up to accept that kind of number. They had to go, and the clerk's office said, well, our system is not, probation, was it probation office, said that, clerk of course, they said the system is not designed for this. We gotta make some changes to our system before we can accept the payment.
How many payments have been made?
My attorney's doing that, I'm not totally sure at this moment.
Yeah.
You'd have to check with Jennifer Branch.
Yeah.
And are you guys helping with that, or is that all on you?
No, the community has been helping with that. They've had fundraisers and are still doing fundraisers to raise the money.
But when you look at some of the charges, the bulk of those charges, when you look at the fees, all of that occurred after the one charge that she was convicted of. Wrongfully.
Wrongfully, after 3 jurors said not
And
guilty.
that happened afterwards, and they ran all those numbers up.
And that
The
charge-
taxpayers were on the hook for over $750,000 that we know of, just to deal with the first trial, and then whatever they did to get to the second trial. They were paid for preparation for the second trial, and that was to the tune of another 100 and some thousand. It was 450,000 plus for the first trial. Then they added all those other fees up. Not to mention all of the appeals and things that are still circulating around. So, but she should not be held to any of this. Based on what Jennifer Branch presented, we think that's reasonable, given the circumstances, and we would hope that he would also see it that way. But if not, then we have to pursue it from a different angle.
Have you left any phone messages, letters, or has the motion's pretty much been the avenue of getting his attention at this point?
Well, I can't speak for the attorneys, but
I can speak for the attorneys. The motions are, I mean, that's the way that you go through the court system. And so the motions have been filed by Jennifer Branch, David Singleton for months. And so we're just waiting on the legal process to run its course.
so the question is, how many other citizens have been treated this same way in some similar stance at a lesser amount and never challenged? Everything that's done in the court system, there's a method by which to do it. And if judges take lead way to extend the rules or to stretch the rules and all these things, similar to what I'm seeing here, then it's going to be challenged. Any further questions? All right, gang.
Exonerate Judge Tracie Hunter now! Exonerate Judge Hunter now! Exonerate Judge Hunter now! Exonerate Judge Hunter now! Exonerate these men and no justice, no peace! No justice, no peace! No justice, no peace! No justice, no peace!
There are a lot of people that are very disheartened by this entire situation in the community. This has torn our community apart, and I think that it has exposed some serious problems with our criminal justice system, especially here in Hamilton County. And there are folks who are going to be running for office and all of these things. Not only this group, but there are many groups are going to be looking very closely at how We're gonna be holding folks accountable.
Judge Nicolacker is up for re-election this year, right?
Absolutely.
It's time to remove
There's a number of
Peter
changes.
Dinklage
There's-
off the bench. Leaders.
But more importantly, this again brings the community into the light of, was this done, and how many other people have been impacted by it. And I'm sure if you research your court records, you will not find for you all in the near future, what's coming is some of the things that she had to endure in the justice system, inside the jail, especially the way women are treated inside of the system itself. One of our members, Senator Antonio, just introduced a bill regarding allowing prisoners to detox in their cells. Some of the inmates have died. I know of